Gary, who's coming down, is in his second year as dean here. He came to us from Cornell Law School, where he was the associate dean, and before that he taught at the University of Texas. As he's an expert at conflicts of law, he's author of the leading casebook, now in its 4th edition, and this is a dean who really, really gets international law. He's been a huge supporter of the Cox Center. In particular, he helped me convince the faculty to create our new International Tribunal Externship program, by which 5 students this semester are at various tribunals around the world, including Cambodia, and they are getting credits. And that was not an easy sell for the faculty. Only a true politician could have gotten that through, and I really appreciate Gary for doing that. Please join me in welcoming our Dean, Dean Simpson.
I'm delighted to be speaking at this event. Any event that Michael organizes goes beautifully. You can always start with that as a given. I'm delighted to be here with all the distinguished speakers, including my colleague Henry King. Any conference at which Henry speaks is ensured to be a terrific conference. And I also want to acknowledge we have the Institute for Global Security and Policy with a new director. I don't know if Bob was introduced, but Bob Strassfeld here is a new director of the Institute, and really delighted he's taken that on. The law school reached an agreement a year ago under which we have some students working directly with Cambodia prosecutors, including today's keynote speaker. The students research various legal issues, submit memoranda on topics such as conflicts between Cambodian and international legal procedures, whether atrocities can be deemed genocide where no specific ethnic or religious group was targeted for killing. Michael traveled to Cambodia about a year ago to provide training for the prosecutors and judges of the Cambodian tribunal, and thanks to his work there, the law school here was the first to send students as interns to the tribunal. The keynote speaker today, Robert Petit, is a co-prosecutor for the extraordinary chambers in the courts of Cambodia. He and his co-prosecutor seek to hold accountable those who were responsible for creating Cambodia's notorious killing fields, where an estimated 1.8 million Cambodians died between 1975 and 1979. Mr. Petit is an attorney with Justice Canada's War Crimes Division. He's currently serving a 3-year term in Cambodia. He has worked in international tribunals, including those for Rwanda, Sierra Leone, Kosovo, and East Timor. He started his international tribunal work as an investigator and then became a prosecutor in the trials of some of Rwanda's most infamous Hutu leaders. He served as a legal officer in the Office of the Prosecutor of the International Criminal Tribunal for Rwanda from 1996 to 1999, a regional legal advisor for the UN mission in Kosovo from 1999 to 2000, a prosecutor with the Serious Crimes Unit for the UN Mission of Assistance in East Timor in 2002, and a senior trial attorney in the Office of the Prosecutor for the Special Court for Sierra Leone from 2003 to 4. Obviously, an extremely distinguished career. Before that, he was a prosecutor in Montreal for 8 years. So I would please welcome Mr. Robert Petit as our keynote speaker for today.
Thank you, Dean. Thank you to the Cox Center and Case University and Michael for the invitation. To be quite honest, I didn't know I was going to have to talk for about, 45 minutes. If not, I would have written a longer bio. And to be quite honest, I took perhaps a little bit of the easy way out in picking my subject for today by basically telling you a little bit more about our tribunal, because in essence this is going to be a sales pitch, at the end of which I'm going to ask for all of you, if you can, to contribute to our tribunal in diverse ways. As was said, I'm the international co-prosecutor for the tribunal. I think the ECCC is a pretty long term for it, and everybody knows it as a Khmer Rouge tribunal. I'm the co-prosecutor because it is a hybrid court, the latest of its kind. And I have a national colleague, Ms. Chia Liang, who is a Cambodian national, who has, according to the statute and the agreement, the same powers as I do. Let me give you a little bit of background. Now, probably most of you in this room, well, some of you in this room, know about the period by which we're interested in. Everybody has come to know the Khmer Rouge era and the atrocities committed during it. Basically, from 1975 to 1979, which has become sort of a mantra in Cambodia, 3 years, 8 months, and 20 days, a group, basically the Communist Party of Kampuchea, took power in Cambodia following a long insurgency fight. And although at the beginning the Communist Party, the Khmer Rouge, were hidden within a front coalition, eventually came out of the political closet and took power. And during that period, they set about basically to alter fundamentally Cambodian society along ideological lines. Now, from this point onwards, you'll allow me to be a little bit coy, because obviously all this is under litigation, and I'm in the position that I am. I have to be a little bit careful about what I say. But we have alleged with the first case and through our press release that indeed the Khmer Rouge at the time set out to fundamentally alter Cambodian society, and did so by agreeing to commit a series of crimes, which we've qualified diversely, but among other things by persecution and genocide, to basically achieve a classless, communist-inspired society. And it was interesting, the question from the outflow room about racism being a precursor or a basis for a genocide, and the discussion that ensued. Basically, I think at the basis of all this is differentiation. As long as you have one group that decides that there is two classes of people or two types of people, and one has less rights and less value than the other, then you have what we're in the business of. And according to Khmer Rouge policy, this differentiation was based on ideological lines. And they set out to try and erase those lines by basically suppressing every individual rights known to us. And in the process committed, I think it's fair to say, mass atrocities of a kind and of a scale that's, certainly stands out. We have alleged, and I think demographically speaking, the safest number is indeed about 1.8 million people who have died as a result of these policies, about a third of which can be alleged to have been through mass starvation and overwork, and a third of which through direct execution. And among these crimes as well, included in it, were the setting up of a countrywide security centers system. These security centers basically were used to identify and process and kill enemies. Now, because of their definition, their ever-expanding definition of enemies, these came to basically encompass anybody that was or perceived to be opposed to or an obstacle to those changes that they sought to achieve. So you had massive purges of first-class enemy classes, former regime officials, monks, ex-military, capitalists or feudal capitalists, etc., etc., and eventually also opponents from within Khmer Rouge cadres themselves who were perceived to be enemies of the policies. Now, this lasted, as I said, 3 years, 8 months, and 20 days. And you have to remember we're talking about the 70s, obviously, and Indochina, obviously a very critical period in the history of the world. Throughout the period, though, even though while they were in power, the scale of the atrocities, the commissions and the scale of those atrocities was known, I think. I think it's safe to say. But only probably after the regime became, or was chased out of power, became less and less deniable. Yet, even after Vietnam invaded and they eventually defeated the Khmer Rouge in 1979, the Khmer Rouge themselves remained a military factor in the life of Cambodia, and was also a politically recognized entity until the 1990s, and indeed held the seat of Cambodia until, I'm not sure I remember exactly the date, but represented Cambodia at the United Nations, even after the evidence was more and more undeniable of the atrocities that they had committed. So this morning the discussion was a little bit, well, was interesting to me, because no matter how dedicated we all are in this field, it always comes down to the politics of it and if somebody will let us do our job or not. But in terms of accounting for these mass crimes, there's actually only been 2 instances. Right after the fall of the regime in 1979, the Vietnamese government, or Vietnamese-led government, set out to hold a trial of basically 2 individuals, Pol Pot and Ieng Sary, who was a then Minister of Foreign Affairs. And they were tried for what the indictment called genocide, but if you read the indictment, it was basically crimes against humanity, or so was the definition of it. And they did hold that trial in Phnom Penh, in a historical theater. And interestingly enough, we have an observer of that trial, Professor Quigley here, who was there in 1979, who observed the trial. It was a trial in absentia, because the Khmer Rouge, after having been chased out of Phnom Penh, took back to the bush and stayed there until the 90s. It was a trial in absentia, which had, on the face of it, a lot of evidence, and a lot of credible evidence. Procedurally, the trial was not probably up to standards. And in fact, if I remember correctly, the first statement, the introductory statement by the defense lawyer, an American, was that my clients, those monsters, are notably guilty, or something to that effect. So obviously the trial was not what we would have hoped for accounting for these types of crimes. But it did bring forth a lot of evidence that really made it quite clear, if it needed to be, in 1979, that the Khmer Rouge regime did commit mass atrocities, and that the Cambodian people, to the tune of 1/4 of its population, perished under that regime. At the end of the trial, these 2 individuals were found guilty in absentia, as I said. And thereafter, basically no accounting for it. The Khmer Rouge, as I said, remained a political force. There was no call, as far as I know, or at least that call was quite muted, by the international community to hold them accountable, to hold anyone accountable for these crimes. Until basically the Khmer Rouge became basically a non-entity in terms of military capacity. And that took until the 1990s and various political developments. And indeed, one of the reasons that the Khmer Rouge became a non-entity was that there was a deal made with, among other people, Ieng Sary, to demobilize his forces, and by doing that, he received a pardon for his previous conviction. As you know, Pol Pot got the ultimate pardon in 1998 and is no longer with us. But, however, because again for political consideration, in 1997 the government of Cambodia, such as it was then, which was composed, it was, I guess, a hybrid government. They were basically Khmer Rouge aligned forces with the monarchy, and former Khmer Rouge aligned with the Vietnamese, who requested the international community, the UN, in assistance in setting up an international tribunal to try the former Khmer Rouge. And right after sending that letter to the UN, basically backtracked for 7 years on that request. There was a long negotiation between the royal government of Cambodia and its subsequent versions and the UN, and the international community through the UN, about what this accountability mechanism was going to look like. I think it's fair to say that one of the reasons for this long, drawn-out process was that, on the one hand, the government of Cambodia composed itself, either in the civilian arms or in the military arm, of former Khmer Rouge. Was quite wary of any accountability for the past deeds, even though some of them, including the Prime Minister by all accounts, although a former Khmer Rouge, had no hand in any atrocities. But they were quite wary of the scope of such process. And they were also adamant that this court be a national court, or this would be Cambodians trying Cambodians. One of the arguments was, where was the international community when we needed it, and why did it keep on recognizing the Khmer Rouge years after their atrocities become known? So how can we trust the international community? On the other hand, you had the UN and the international communities in some particular countries, mostly concerned with Cambodia, who wanted to have an international standard set up for this tribunal for reasons of credibility and also obviously advancing international criminal law. And as I said, the negotiations were quite long and drawn out, and at one point the UN even walked out. The Office of the Legal Advisor walked out on the negotiations, only to be reluctantly pushed back by some countries to the table. And eventually a compromise was reached on certain key issues, and actually David Sheffer could probably tell us a lot more about that than anybody else. Because, as I said, one of the main sticking point was Cambodian control over the process. And the way this compromise worked out was that we do have indeed a hybrid court. We have a court with an international component. However, the majority of the judges on both the trial level and the appeal level are Cambodians. At the trial level, we have 3 national judges and 2 international judges. At the appeal, we have 4 and 3. However, for any positive decision to be made, there needs to be what's called a supermajority. Senator Kerry apparently was one of the main driving force behind that compromise. A supermajority means that for any such positive decision, at least one international, for example, would have to agree with all his national colleagues. What happens when neither of those scenarios happen? In other words, if the nationals and the internationals cannot agree on something, including a verdict, that remains a problem. But as I said, a compromise solution was reached. These tribunals are always compromise solutions, and it's one of the things that I've been repeating since I've joined the tribunal to journalists and civil society, is that these tribunals are always about a certain measure of justice. Not everyone who should get tried gets tried, and not everyone who should be found guilty gets found guilty. But what they did come up with is a very unique model, actually, of a tribunal, of a hybrid court. We, by statute, by the agreement, and then by the law, Cambodian law, who created the court, we have jurisdiction to try what's called the senior leaders and those most responsible for the crimes committed during the period. That is, for example, I would submit markedly different than the standard of those who bear the greatest responsibilities that we had in Sierra Leone. I would argue that those most responsible is a much lower threshold. Senior leader, however, refers to obviously some kind of objective criteria by which we will, for example, have to establish a structure and place somebody in that structure and show that there was some power attached to that position. Although the French version says leader historique, historical leaders, which I'm not sure what that means. It sounds funny, but we have 3 official languages in the court. No official translation in either English or French of the agreement or the law. And the rules, the internal rules that we've adopted, I'll go into that in a minute, also differ markedly. I mean, no surprise, obviously, you can find 2 lawyers who speak the same language arguing about one word quite differently. So imagine 3 different languages with different lawyers coming from different backgrounds trying to understand what the law is. Because one of the problems that was addressed by this agreement was the state of the law in Cambodia. As a hybrid court, as a national hybrid court, we are tasked with applying national law such as it is. And the problem with national law is that because of the historical events, is really far from clear or homogeneous, and certainly left to a lot of interpretation. Cambodia is a civil law system, basically a French civil law type system. However, because of its history, different types of criminal procedures and law have been introduced, mostly by the UN. There is also the problem of having a whole generation of lawyers that were killed. So there is obviously problems with the level of competency. And there is also a confusion, I think, that happens perhaps relatedly between practice and law. We have endless meetings with our national colleagues trying to decipher what is the difference between the practice and the law, and where is the basis for a legal argument, or is it just practice? However, the law tells us that we have to apply national law, and if there is a gap, a contradiction, or a clarification in the applicable national law, we can revert to international standards and practice, again, whatever that may be. One of the first conversations we've had with our national colleagues is that there is not a book called International Criminal Law 101, which encompasses everything. So we are left to try and figure out how to amalgamate these 2 bodies of law. The agreement figured that all the judicial officials would do that at their own stages. Now, as I said, this is a civil law system. So we have a prosecutor, we have an investigative judge, and we have the judicial official, the chambers. Because of the hybrid nature, and again because of the concerns about how this tribunal would work, there is 2 co-prosecutors, one national, one international, 2 co-investigative judges, and the judges, as I mentioned. At each of these levels, those judicial officials were supposed to be able to figure out what national law is, and if not, then agree on what applicable international standard is. Now, the judicial officials decided from the very beginning that to make sure that everybody was playing by the same playbook and to basically try and make sure that this process was going to be up to standard, to come up with a more comprehensive set of rules that would apply to the whole process and that would encompass both national law and international law. Instead of, like I said, having every stage participants interpret it as they go along. So we did come up with those internal rules, and I'll talk about them a little bit later. So we have jurisdiction over senior leaders and those most responsible. We have our law. We have our time frame, signed 1975 to 79. And in terms of the crimes, we have the usual. We have crimes against humanity, war crimes, genocide. We have as well although I got to say, interestingly enough, we have, which may or may not be a typo in the genocide definition. Instead of having as such, we have such as. which could be interpreted as giving me a little bit more leeway, but I'm not sure I'm going to go that far. And we have national crimes, murder and religious persecution, and we have crimes against protected persons and destruction of cultural property, which I would love to have somebody tell me exactly what those two are and if they are crimes indeed. Another particularity that is built into our law, and that will give you an idea of our expected problems. There is built in within the agreement and within the law a conflict resolution mechanism between the co-prosecutors or the co-investigative judges. I think it's fair to say that part of the concerns and part of the reasons the negotiations took so long is that the royal government of Cambodia was quite concerned, as I said, about limiting the scope of the prosecutions to either certain individuals or certainly a certain numbers of individuals. Now, let me say if I'm outright, I personally see nothing wrong with that sort of limitation. Again, they are part of all these courts. All these courts come within a context of rebuilding, of reconciliation, and certainly are not supposed to further create problems, but try and help solve them. So I think it's perfectly legitimate for these statutes to limit or to identify or to guide, depending on how you want to qualify these terms, the prosecutors in their work. Problem is, in this one, they told me that it was senior leaders and those most responsible. They didn't say Mr. X, Y, and Z, and they didn't say 7 people. So it's basically left up to us, based on the evidence and based on the law, and based on whatever objective and subjective criteria we can come up for the credibility of this process, to say, well, this is it, there's only this number of people. And from the very first day, I think, when I was there, I've been asked how many and where's your list and how many people and who's on that list. There's always a list, obviously, but at one point the job becomes to make a line after one name and before the other. But concern about the scope of the prosecutions, they being international community and Cambodia, have put into the law a process by which if the co-prosecutors or the co-investigative judges do not agree on who should be prosecuted, we have to go in front of the pretrial chamber. There is a pretrial chamber that is basically there to resolve those conflicts, although the internal rules have now expanded their jurisdiction quite greatly. We have to go in front of that pretrial chamber and tell the judges why we think somebody should or should not be prosecuted. And then that pretrial chamber, according to the agreement, if it cannot reach this supermajority, stopping us or telling us to go ahead, the prosecution proceeds, whatever, again, that means. So, and the same for the co-investigative judges. The investigation proceeds. So it's quite clearly envisioned, I think, as giving the power to the international components of the investigative process. A measure of control, or at least, a measure of control about who should get prosecuted. And I have to tell you that it's obviously quite a concern from Cambodians to, ordinary Cambodians to the level of governments about who is going to be prosecuted. As I said, I have to be careful about how I go about this. I think, and some of the issues that we're going to be facing, I think, are quite novel, either because of these, very interesting and very specific mechanism we have there, built into this the structure itself of the court. This is my 4th tribunal. This is certainly, in terms of the structure, the most complex to run. We have a chief of administration. We don't have a registrar, which is a problem, although I've known registrars to be a problem. No names. We don't have a registrar. We have a chief of administration who is a national Cambodian, and we have a deputy chief of administration who is a UN staff. The way the court is built, you have certain areas that are under the jurisdiction or the responsibility of the national side, and others who are on the international side. The UN component of the court is, in UN speak, an assistance mission, which means that, again, we're there to assist. And we have, or the UN has, for better or for worse, certain limited responsibilities. The key areas are all under the Cambodian national responsibilities. We also have a very limited budget. I was at a conference last year in Beijing where the president of the ICTR and the president of the ICTY were noting the fact that they only had about 1,000 or 1,100 staffers, and I don't know how many millions of budget. And then there was the guy for the IIIC, the Hariri Commission, who basically told us that only for security of Mr. Brametz and his colleagues, they had 40 million. We have 56 million for the 3 years to prosecute people responsible for 1.8 million murders. Obviously, that's not enough. Again, obviously, I can tell you, based on my experience, those projections are never enough, and you always have to go back to the well. It's not like you can stop in mid-budget and say, well, we've run out of money, you, and you get out. As it turns out, our budget will be expanded by mid-next year, I think, which is half the time that we were supposed to take. So by the end of this year, there will be an additional fundraising to try and at least get us to 2009. We don't have a limited time in terms of the statute, but the initial budget was for 3 years. The expectations was for 3 years. Our appointment, as you said, is for 3 years. But now, having spent a year between the nationals and the international side negotiating and drafting and adopting the internal rules, and realizing the scope of these things, I think it's quite clear that the 3-year mandate is probably going to have to be extended for at least another year if we want to get through this process with any kind of credibility. But some of these issues that we have, therefore, relate to the structure of the court. Some of the more interesting issues for you, and things that keep me up at night, are more legally related issues. As I said, for example, we now have adopted a somewhat comprehensive set of internal rules that we say encompass both the applicable national law and international standards as appropriate. Given that the statutes and the law gives the co-prosecutors, the co-investigative judges, or the judges the right to seek guidance from international standards. One of the challenges from my colleagues on the other side of the bar will be maybe that we don't have the right to adopt comprehensive internal rules, that we should apply national law and then seek some guidance, but certainly not to import wholesale, perhaps some context. One of the other interesting challenges, as Bill mentioned earlier, will be the state of the law as it relates to our time frame, 1979 to 1975 to 1979. As Bill said, for example, is there a need to have crimes against humanity linked to an armed conflict? How was that settled law by 1979? How do we prove that? Those are interesting challenges. We had the whole child soldier issue in Sierra Leone was quite interesting. As some of you may know, this is the first time that it got litigated and indeed somebody was found guilty. But we had first, and for that we had the great benefit of some very, very good amicus briefs on determining when, if indeed when, child soldier became a crime. But it is one of the things that we're going to have to certainly look at. Another argument that we're getting already is, can Cambodians try Cambodians as a majority? All these other tribunals had a majority of internationals. Now, I think it's safe to say that every Cambodian living is a victim of the Khmer Rouge in one way or the other. Now, does that pose a problem in terms of the credibility of the judges, in terms of the appearance of impartiality? I'm sure that's going to be raised as well, although that's going to be a difficult one. And then again, having Cambodians in a majority deciding on that issue, I think it's not going to fly very far. But I mean, I think it's a legitimate question, especially considering the difference in this court. One of the, perhaps the thorniest one that we have, and I'm going to talk about it later in the panel, is the genocide issue. A lot of people talk about the Cambodian genocide. Some people have written about the Cambodian genocide. I have to say, and again, I'm going to talk about this a little bit later, but I think it's fair to say that for the majority of the population in Cambodia, the word genocide comes to mind when they talk about what happened to them. Now, genocide happens to be a legal term with some very specific elements to it. One of the things that we're going to have to face is, do we have cases of genocide? And if so, against whom? I mean, concerning whom, rather, concerning which group? And if perhaps with more difficulty, if we don't, how do we explain that to people? Another aspect that we're going to have that might be of interest is the impact of a pardon, should the person who was pardoned be prosecuted, for example, totally hypothetically. How does that impact? In 1975 or 1997, could you give a pardon for these crimes? Don't forget now, this is a national court, not an international tribunal, or, well, we'll see how. The first judgment calls it an internationalized court. So can a national court or national government give a pardon and then take it away, basically? Aside from the issue of, was the trial legitimate initially, and all the legal niceties. One of the things that also we have to, that I personally have to wrestle with is the whole civil law concept, and how it applies to these types of cases. Most of the courts, all the courts that I've been involved in, have this mixed, basically, of two systems, as you all know. The procedurally more common law inspired, evidentially more civil law inspired. And one of the questions this morning, I think, was quite on point. You can't do these types of cases, I think, with a strict common law evidentiary approach. You just wouldn't be able to do it. So that's why these tribunals have adopted the rule of relevancy as the only one, and letting the judges earn their salary and figuring out what's believable or not. But the civil system has also its own, what's a nice diplomatic word, its own way of doing things. That reflects, for example, on collecting evidence. For example, investigators in the civil system can only work within the parameters of a very specific written order from the judge or from the prosecutors. They have very little initiative in conducting their investigations. There's also a whole aspect of the separation of the roles between prosecutors and judges. In civil system, as some of you know, they're all basically treated the same. 1 month you can be a prosecutor, next month you go to another place, become a judge, or come back and become a prosecutor. And in the national system in Cambodia, they are basically part and parcel. They sit on the same level, wear the same robes. That has obviously created a problem with some of our international judges who come from civil background, and for me as well. Perhaps a bigger problem to me, I think, is the whole confidentiality aspect of the investigative phase. Now, as some of you may know, the preliminary investigation that is conducted by the prosecutors is normally very short. In this, because of the circumstances in our work, we took 1 year, but it can be very short. Once you do think that there is a matter to be investigated that can be qualified as a crime under your jurisdiction, and if you have somebody identified as responsible for that crime, you forward that to the investigative judges, who then conduct the investigations. That investigation, both of those investigations, are by definition secret. And I have 2 minutes. Now, these investigations can be very long because the investigative judges are tasked with assembling a dossier, a file, with all the evidence on both sides of the fence, exculpatory and inculpatory. And it can take a very long time, again, mostly due to their procedure. But all this is secret or confidential. And at the trial, trials are generally very short because all the evidence is in this file that the judges must read, must take into consideration when they reach judgment. And the witnesses get called on a very ad hoc basis to either confirm, deny, or clarify certain things, but very short testimonies, no cross-examination, none of the things that's there. So theoretically, you could have a Khmer Rouge trial that would last a couple of weeks, 3 weeks. I don't think that's going to satisfy 30 years of expectations. So I think that's going to be a problem which the rules have tried to address in some ways. Now I have 1 minute, which I'm going to use to, well, as a sales pitch, basically. All the tribunals I've been involved with have benefited tremendously from the work of interns, as Briand and as others from this university. The whole forced marriage as a crimes against humanity issue came out of a memo that one of the interns dropped on my desk in Sierra Leone because she thought that this, which was a signature of the conflict, basically kidnapping women or girls and forcing them into a matrimonial type relationship for years and years in the bush, well, that shouldn't be, that's not right and shouldn't be a crime. And indeed it was charged. The judges, with all due respect, got it wrong in the IFRC judgment, and it's under appeal. But interns contribute tremendously to this process. They have energies that we old folks don't have anymore, and they have this insight that they bring that is just invaluable. We can and need that help, and we have a few universities that are providing us with interns. I have to stop, but I will keep going, with all due respect. And as well as research capacities and litigation support. Hell, we'll take books if you have them. We'll take assistance that we need to make this process go. To also create, hopefully, the next generation of guys who will be driven by this and will carry on this type of work. Because for the politics of it to become unnecessary or to become irrelevant, we need these types of kids who will go on to try and push the limit so that the law takes precedence over the politics. Thank you.
Do you feel that you're sort of in a breach of implied contract, that in return for the Khmer Rouge laying down the arms, that they'd be left alone?
Thankfully, I'm not a politician. I'm a lawyer. So you give me a law and I'll prosecute them. The rest is out of my ambit. The government of Cambodia decided that it was ready to write or to sign an agreement by which some people were going to be prosecuted. That's what I'm going to do. Now, as I said, there's always a realities to this. And we know, for example, that should we expand too much the scope of our prosecution, we risk defeating one of the purposes of this court, which is to foster national reconciliation through accountability. If you start going after too many people, it makes some people nervous. And all it takes is a grenade in Angkor Wat, and, I might have to go back to Ottawa. So we're all conscious of the limits of this. But obviously the government of Cambodia decided by signing the agreement that there had to be some accountability for what happened, and that's what we're doing.
To what extent does the domestic murder laws conflict with or interact with the international side? And does the international side have any adjudication duties with respect to the domestic crimes?
Well, the domestic murder is part of our jurisdiction. We can charge it. There is a legal question also. They're attached to it because under their system there is a, what's the English word? It's prescribed. Prescription? Yeah, there's a prescription. Statutory, sorry, what he said. For murders, for national crimes. But yeah, we have a right, just as, for example, in Sierra Leone, we had the right to charge for a couple of national infractions, murder, I think, and arson, I think, which we've never did, which David took the stance of not charging. So we have that jurisdiction to do so. And it's basically the same factual basis, so. Not him. Not him, no.
How are the judges chosen in Cambodia?
They are named by the Supreme Council of the Magistracy to their position. I assume, well, they're named. I'm sorry, I can't really answer that much more than that. I mean, they are rebuilding the justice system, as I said, because most of the lawyers either fled or were killed. So there is now a magistrate school which is graduating some students. Most of the judges who are now on the bench either were judges before and survived the regime and came back, or had studied abroad and came back, or in some cases had not really studied law but were still named and kind of learned on the job. Which is not a bad way to learn, actually. Makes for a lot less theoretical arguments.
What is your relationship with the people who investigate? I mean, have you some control over that, or you can ask people to do things for you? Is that it?
Well, actually, in this system of law, investigators, judicial police as they're called, have very little, as I said, initiative. They can only do what we tell them, and we're supposed to tell them from A to B to C what to do, and then they do it and report. Some of our Anglo-Saxon investigators find that very difficult to live with. So in law, we have authority over them. Now, we were supposed, the initial agreement and the budget and the staffing envisioned that we would use only the national police to do so. Now, the national police, by all account, is not equipped to do this sort of investigations, and it's quite normal. No national police force is prepared to do that sort of thing. But by all accounts, it's also very deficient in a lot of ways. So we have international investigators who are now investigators, was part of the rules that we promulgated, that we could get them sworn in as investigators. They don't have coercive powers, but they have investigative powers. So we have internationals who are working as investigators / analysts / researcher. And they have assembled to us, for us, a great deal of information. The good thing about this tribunal is that there's 30 years of information that's been gathered on what happened then. It's also the bad thing about this tribunal is that there's 30 years of information gathered. You have to go through it. You have to make the judgment of what is information and what is evidence. And you have this expectation. I was told again at this conference in Beijing, well, why is it going to take you so long? The NGOs have all done it for you. It wasn't exactly a matter of backing a truck to an NGO and then carting off the evidence to court. It's not how it works, but you have to be able to explain to people that, because they will tell you, well, everybody knows what happened. It's all there. It isn't. All right, all right. But I claim my right not to answer.
Robert, can you describe to us, just out of interest, how is your working relationship with the Cambodian co-prosecutor and the Cambodian side of your office? Is it working well together? Have you reached any points where that dispute settlement mechanism might be triggered? Just a little bit of insight on that working relationship.
To start with, no, we haven't reached the point where we would go, where we would need to resort to that. To be quite honest, I suspect that we may, and I think that's just again, you put two lawyers in the same room, you'll have three opinions. So I think it's almost a given. But so far, the relationship has been quite good. It's difficult. I mean, every single meeting we have, from division of work to talking about GCE, we have to have an interpreter present, because my colleague's grasp of English is not that good. She speaks fluent German, but that doesn't help me. So every single decision has to be interpreted, translation, explained, and when it comes to judicial acts, this requires a lot of time and a lot of resources and a lot of patience, because it's quite normal for her not to want to sign anything that she can't read, and not to express opinions that based on things that she can't understand or again can't read. So it's quite legitimate. It's the most hybridized of these courts that I know, and it represents its particular challenge and its particular reward as well. I mean, in Sierra Leone, we really, Dave is not here, but we really hit the ground running because we had these nationals involved with us right from the beginning. We had national investigators, excellent ones, who had lived through the conflict, who knew who did what, and most importantly, knew where they were. And I had on my team lawyers, two very bright, experienced, so good in fact that they quit and went back to private practice. That again, not only lived through the conflict and could make us, the foreigners who come in and then go out, make us explain what the conflict was about, but could also help us, substantively. So, in this court in Cambodia, we have teams, at least our office does, integrated teams of people working on specific issues as a team. With different levels of input, obviously. We can't bring anything in terms of a Cambodian national law. They can't bring anything in terms of international criminal law. So we're there to hopefully, put those two together and come up with a product. So far, so good.
What is the status of current civil rights in Cambodia, such as persecution of the church, minority, etc.? And then secondly, how does current civil rights abuses occurring at present affect or hamper war crimes prosecution occurring at present?
I think understanding what my position is, you'll allow me not to answer either of those questions. I'm sorry. I'm not going to make comments on current political situation in Cambodia. That's not my job, and I think I'm not sure it would be useful for anything.
A few moments ago, you provided an implicit comparison between Sierra Leone and the current court in Cambodia. Would you be willing to extend this and speak about East Timor and Kosovo in terms of such factors as the degree of hybridization, budget, time you had available, and things of this sort? And in short, what are the elements of success that you might draw forth from those experiences?
Well, I worked in East Timor as a prosecutor on the Serious Crimes Unit at the very beginning. And in Kosovo, I was supposed to be the first prosecutor, the first international prosecutor, but various reasons declined. So I think I can compare it. Sierra Leone was probably the best lessons learned example that I've been through in terms of doing things right. Maybe because it wasn't a straight UN operation. I can say that because I don't have a UN contract. I'm just a UN official. I think East Timor, in terms of the bigger picture of East Timor, one of the things that I found the most, the saddest, basically, is that what was left to prosecute were really the illiterate peasant enrolled in the militia. All the real responsible, all the real culprits, all the Indonesian generals and colonels and all these guys had fled before we got there. The trial that I did, the only one that I did, was exactly a poor sap. Poor sap. He did kill 3 people, but he was part of the militia that was enrolled and did what he was told for whatever reason. So these trials and the jurisprudence that come out of it, and the whole exercise, you can certainly question, what it contributes. As you can see now, East Timor has gone back to a very difficult time, and they're now trying to reinstate the serious panels. But we were just discussing that earlier. If they do it with the same mandate and the same resources, it's useless. Stuart was there as well. He can also testify to that if what they do next is not different, then it's going to be a useless exercise. Kosovo, I think Kosovo was very important in that it allowed, without the international prosecutors and international judges, I don't think the system, I don't think the province would be where it is now in terms of being able to rebuild. There's still a long ways to go, and again, I'm going to check what I say, but the international prosecutor and judges system allowed, to, first and foremost, to take the heat off the Albanians' judges and prosecutors, to allow certain cases that would never have gotten prosecuted to go forward. Eventually, it worked both ways. Not only the Serb cases went forward in the right way, but the Albanian cases also went forward in the right way. I think it was absolutely essential. Although the now Foreign Minister Kushner, who was the administrator at the time, was quite opposed to international prosecutors and judges. He had to change his mind when the French troops got 12 Albanians in a gymnasium and refused to surrender them to the Albanian judges. It was necessary, and I think to a certain extent it worked. But you have to have, this is only a temporary mechanism. I think the Bosnia example is a very good one, where there's going to be a phase out of the international presence. And again, maybe Stuart can tell us a little bit more about it, but I mean, I think it's a much more workable model than what's now in Kosovo.
No one else is asking any questions. I guess this will probably be the last question as well. Robert, just reading news lately about your court, I guess the biggest story of this month was that one of the co-investigating judges got appointed to the Supreme Court. And what in the world does
Court of Appeal.
Court of Appeal. What in the world does one do in that situation? Can you give us an update on where things like that stand?
Yeah, and I should have mentioned, again, that would have helped my appeal for help. In July, we forwarded the first case right after the rules were adopted. We waited that long because we wanted to make sure we had the right, as I said, the right playbook. We forwarded the first case to the investigative judges. 5 suspects, several crimes, including genocide. And I think from the level where we aimed, I think is pretty good in terms of accountability and responsibility. So that case is before the 2 co-investigative judges, one of which got named out of the blue by the government to head the Court of Appeal. The president of the Court of Appeal got fired for apparently taking a bribe, allegedly, and he was named to help restructure that court. And obviously the timing could not have been worse, because we were at the very beginning of this, and it's a huge amount of information and evidence for the judges to master. Civil society, the UN as much as it could, and a lot of people expressed strong opinions about this nomination and how it basically looked like executive interference into the process. And there is a lot of people in Cambodia and outside of Cambodia who suspect that there will be, and that there has been and will be, political interference in our process to make sure that nobody alive is left to be tried or that sort of thing. I'm not saying it's true, I'm just saying that's what people are saying. Eventually the government, well, the Prime Minister, came up with this statement that actually what he actually meant, or what actually the Council of Magistrates meant, was that the investigative judge was going to hold both positions. In our system, as I forgot to mention, there is reserve judges and reserve prosecutor. My reserve prosecutor is an American, Paul Coffey, who was in Kosovo. There's no reserve co-investigative judge on the international side, but all the national positions have reserve judges, so that if one cannot serve, he or she is replaced. And right after this co-investigative judge was nominated, he said that his reserve was going to stand in and it would be a smooth transition. As I said, there was a lot of protest, and basically the government backed down, and he's, at least in theory, is holding both jobs. Not sure how that's going to work, but it of course was not a good thing, and it could have had major impact if he had indeed left. So far, there's no discernible one, but we'll see.
Well, let me ask everybody to join me in thanking you for what you've